Excuse me? This is funny, Ms. Reed?
Tensions running high in court.
Anything else you want to say, Mr. Jackson?
I'd like an answer from the court.
As the jury deliberates for its first full day, while outside court, crowds of Karen Reed supporters grow by the day.
We've watched the trial the whole way through, and we wanted to be here for the verdict.
We are covering it all for you tonight on Canton Confidential, the Karen Reed murder trial.
Karen Reed's fate is in the hands of 12 jurors. Welcome to Canton Confidential. I'm J.C. Monahan.
And I'm Glenn Jones. The jurors trying to decide whether she is guilty or not guilty in the 2022 murder of her boyfriend, Boston police officer John O'Keefe.
Reed is facing 3 charges: second-degree murder, motor vehicle manslaughter while driving under the influence, and leaving the scene of a crash causing injury or death. Yesterday, the jury was given specific instructions on how to consider these charges.
Now we're getting a better understanding of how they will determine and record their verdict using these forms. Today, heated questions were raised about the format of one of these verdict slips.
Those questions caused a tense interaction between attorney Alan Jackson and the judge. Our Kirsten Glavin is in Dedham with a closer look at what happened.
Karen Reed not taking any questions after day 2 of jury deliberations. Her team reportedly waiting until a verdict is reached.
Karen, do you think tomorrow's the day?
No comment.
The trial off to a rocky start Wednesday with defense attorney Alan Jackson arguing with the judge.
All right, so why are we out here?
Your Honor, I just saw the verdict forms, and as we discussed yesterday, the amendments that the court indicated it would make on the verdict.
Oh, no. Okay, I did not say I'd make it. I said I'd think about it. I said I was tired and I needed to think about it.
Jackson upset that there was not a not guilty box for jurors to check on the 2 lesser charges Karen Reed is facing: motor vehicle homicide and involuntary manslaughter.
I don't really care how it always is in Massachusetts. I care about whether or not it's appropriate.
It's appropriate.
Reed laughing at the exchange, prompting this testy response.
Excuse me? This is funny, Ms. Reed? All right, we're done.
Jackson filing this emergency motion and the judge eventually approving an updated slip.
All right, so the verdict slip will go in.
Also throughout the day, questions from the jury. In one case, asking to see the CERT team report from when state police searched the property at 34 Fairview Road. The judge saying all evidence has been provided.
What you have is the evidence in the case. You won't be receiving any additional evidence.
Now, Karen Reed did not take any questions leaving court today. As far as the jurors go, they'll be back here first thing tomorrow morning to continue with deliberations. Reporting here in Dedham, I'm Kirsten Glavin, NBC 10 Boston.
Okay, Kirsten, thank you. Joining us virtually tonight is legal expert and dean at the Massachusetts School of Law, Michael Coyne. So, Michael, let's begin with those concerns brought up by the defense this morning about the verdict slip for the second charge. We're going to show our viewers images of the original version of the verdict slip and the amended version. The point of contention, Michael, was the not guilty line, which we'll show people in just a moment. What was the defense arguing there, and did they have a strong argument?
I think they did have a strong argument. The forms should have been clearer from the outset as to if they were finding not guilty on the lesser included offenses, there was a place to check on that. What puzzles me is that the lawyers themselves allowed this form to get to the jury before they had a final say on it. And that's what's odd. Normally, you know what the verdict form will be prior to even closing arguments, so you can tailor your closing arguments around the questions the jury has to answer. And so, like everything else in this case, nothing is done smoothly, and it's all out of the ordinary. I think Jackson's point was right. I think it should have been done much sooner, and Jackson and Yannetti should have been able to sign off on the verdict form before the jury deliberated for 3 hours yesterday with what turns out to be an incomplete form. The court corrected the error, and I'm sure the court and others may not see it as an error. But the fact is if we could be clearer to the jury who come to the jury pool with a variety of education and experience, it makes sense to clean it up and make it as easy as possible so that we get it right.
Which all makes sense, Michael, except for the part that somebody like a David Yannetti or an Alan Jackson could have not noticed that, as you said, before it got to the jury. That does seem like one of those oversights that they don't miss things like that. Do you have any idea of how that could have happened?
No, and we've given props to them throughout. A lot of what they do is textbook, and they've done a great job defending Miss Reed. This is not all on the judge, as some want to put it on her. This is something that, if you're dotting your I's and crossing your T's and making sure that the jury is going to hear your words while they're deliberating, and that's what the verdict slip is. It's, you hope you get the questions you want so that the jury can come back with the verdict you want. And it is a little puzzling that this was done sort of in a happenstance fashion, and it's lucky that ultimately they caught it and it was corrected.
And for anybody who didn't see the proceedings this morning, what we're talking about is having a box for guilty and a box for not guilty under the second charge. Previously, there was only a box for guilty. A question from one of our viewers here, Michael. Ray G wants to know, is there a standard jury form in Massachusetts, or does a judge decide which one to use in every case?
Yeah, it's a great question. Normally what happens is the lawyers to discuss and draft the verdict form that they would like to use, hopefully by consensus. Once they have done that, then the judge either approves it, usually would approve it if both sets of lawyers agree, and then use that form. Or they'll use that case-specific jury verdict questionnaire. And that's the thing here is, yeah, there's a bunch of forms, but every case is different, whether there are lesser included charges, that you have to be charge specific with respect to the verdict that's ultimately going to be returned. So they're all tailored. You may start with a basic set of form or verdict request, and then you're going to tailor it to the situation. And we know this situation is relatively unique, as it's been for the last 2 months. But now we have the set out the charges more clearly and the lesser included offenses. And I think that's where it went off the rails a little bit.
You know, the jury did ask a question. I think we all like to play mind readers when juries come back and ask the judge a question. They asked if they could request the search report, which details the search performed outside the home where John O'Keefe's body was found. We have a clip of the judge's response. We want to get to that. And then, Michael, get your opinion on the other side.
Sure.
Jurors, we're in receipt of your question. Can we request the cert report detailing the search performed? I take this as a request, and the answer is that you folks, you have all the evidence in the case. So what you have is the evidence in the case. You won't be receiving any additional evidence.
All right, clear that up for us, Michael. What is she saying with what she's not saying?
Well, what she's saying is the evidence is closed at this point, right? And so therefore, only in rare circumstances would you ever reopen it. And the cert return, the return from the search warrant itself that the police have to file in court, was not part of the evidence that the Commonwealth offered or that the defendant offered. Since the evidence is closed, they only can use what was submitted properly before the court with the foundation. We've talked about that a bunch of times. So they can't reopen the case to provide that evidence. It's an interesting question as well. The fact is, what it says is they're going to dive into this a lot more deeply than I think the defendant would like. And certainly some of us had thought that the jury would not be out. We're already over 10 hours. Not that the time means whether we're looking at a guilty or a not guilty, but my guess is that Miss Reed is sleeping a little less soundly tonight than she may have the last couple nights.
All right, Michael, let's see if we can squeeze in one more viewer question in the time that we have
Sure.
left. This one is from Rick K. He wants to know, what is the probability, statistically, of a hung jury? And if a hung jury should come back in this case, what would the outcome be?
Okay, I'm a lawyer, not a statistician, so that's a tough question. But, again, this case breaks the mold, though. The fact is that there are people, my sister-in-law says it's a hung jury. Others say guilty, others say not guilty. I don't think we know yet. What we do know is that there are people inside the Massachusetts and across the country who are strongly on one side or the other. If one of those folks is on the jury and feels just as strongly as a lot of people out there, and the other 11 are going the other way, you have a hung jury. I think statistically it's relatively low that you have a hung jury. But the fact is, if you remember, the last big murder case before Judge Cannoni was the one from the Weymouth police officer. And initially, that was a hung jury on the murder charge. They came back, retried him, and was found guilty. So it's not an anomaly that you'd see a hung jury, especially in a case as contentious as this, that very well may be where we're at. And what that really means is then the government has to try this case again in all likelihood.
We're not even going to touch that right now. I don't think anyone has the patience right now for that. Michael, thank you so much for joining us today. Still ahead on Canton Confidential, as the jury deliberates inside, crowds of people are waiting outside for that decision.
When we come back, we'll hear from some of those people braving the heat and humidity to show their support for Karen Read. Plus, a jury consultant weighs in on deliberations.
Welcome back. If you've driven through Dedham this week, you have likely seen a sea of pink surrounding the Norfolk County Superior Courthouse. Supporters for Karen Read making their presence known while adhering to the court-ordered 200-foot buffer zone.
In fact, I actually drove by the courthouse today, so I saw this for myself. It's a spectacle, drawing even more attention to this high-profile murder case. Our Eli Rosenberg spoke with some of those people waiting for a verdict.
On the first full day of jury deliberations in the Karen Read murder trial.
Anybody like some pizza?
Pizza and plenty of support.
I'm feeling a little anxious, but I've been waiting for a very long time for this verdict.
The crowds dressed in pink in support of Read swelling again on Wednesday. A hot, humid day, doing little to tamp down enthusiasm.
We've watched the trial the whole way through, and we wanted to be here for the verdict.
All this going on outside, while inside, those jurors continuing their deliberations.
You never know what a jury is going to do, so it could be a little nerve-wracking.
Canton Confidential legal expert and local attorney Catherine Loftus has sat through many a jury deliberation.
I would not be surprised if we have really different juror opinions. You know, if we have a fair amount towards not guilty and you have a couple towards guilty. So the longer it goes, you get more worried as the defendant.
David Davis has served as an international jury consultant in hundreds of cases.
In a long trial, jurors are often very conscientious and feel that they should take their time and go through the questions they have to answer and look at the instructions and to review the evidence, and that can make the deliberations last longer.
An organizer estimates some 350 people were out here for most of the day, and talking with them, they say, after everything, after watching all of this through jury selection, all those days of testimony, there is a sense they want to be here together in person when the verdict comes down. In Dedham, Eli Rosenberg, NBC 10 Boston.
Thank you, Eli. My sense after being there today is that all of those 350 people know the name Sue O'Connell. And coming up next, our courtroom insider will join our conversation.
She's going to help answer your questions and give us perspective about what the energy is like now in Dedham as we await this verdict. Stay right there. Joining us in studio tonight is our courtroom insider, Sue O'Connell. Sue, you were back at the courthouse today. You have been there just about every single day. You've translated for us what the feelings have been like in that room. Now we have the jury trying to deliberate, no verdict. What did it feel like today?
It was very stressful and very cranky today and very tense inside the courtroom. I think the supporters outside the courtroom, they were also feeling some frustration because I think they had a high expectation that the jury was going to come back today or soon.
Was that an unreasonable expectation?
Yeah, I think so. Considering just the amount, and Michael spoke to it earlier, the sheer amount of testimony we have heard, the sheer amount of evidence, even just some small differing timelines from the prosecution's case, which, you know, aren't really big deals. People make little mistakes, but they want to get it right. So just, I mean, how many days has it been? I don't even know how many days.
It's 29 days of testimony.
How many hours would that
70,
be?
Right. Experts and then, or experts, no, witnesses
yep.
on the stand. And I thought, personally, it would be a quick turnaround until I heard the jury instructions.
Right.
And then all of a sudden, that and I thought, well, now if I have to go line by line, the way she explained it, this was going to take me a little time.
So, you know, outside it's a little frustrated. Obviously, the defense was very frustrated today. There was that back and forth between Judge Cannoni and Karen Reed, who rolled her eyes or did something. I didn't get to see her face completely. You know, and that just shows the frustration that the judge is having with the defense asking for stuff. You know, whether it's their right to do it or not, she's frustrated with it. And everybody, the police are being, you know, great, but still they're frustrated. People are stopping in front of, taking their phones out in front of the courthouse to take pictures, and the state police are yelling at them to put their phones away. So it's really just, it's time for us to just take a deep breath. Remember, you know, this process is about John O'Keefe, right? This process is about finding justice, getting answers. And Karen Reed, her life is also hanging in the balance here. So, but it is testy.
All right, so we've heard from Michael Coyne many times how atypical this case is. So maybe I can't rely on your experience to answer this question from a viewer. It's from Jen F. She wants to know, once the jury has reached a verdict in this trial, how long before it is announced? What's your best hunch?
So I think it's just 30 minutes or so. I mean, and from my experience serving on a jury, as soon as they're in constant contact with their court officer. They're just not in their room far away. The court officers come in. I think there's people that are there to help them. They take their lunch orders. So they're able to estimate what's going on with the jurors. And then the jurors, when they come to a decision, they let the court officer know, and then we get a warning that it could be 30 minutes. So it'll happen pretty quickly once they come to a decision.
They just have to get everybody back into the courtroom.
Right.
So as long as everybody is close by. What about the fact that the jury asked for the cert report? We asked Michael about it, and I know we're trying to play, you know, mind reader of a psychic of what this means. But do you read anything deeper into that? And as Michael said, he thinks it shows their due diligence, that they're really being exacting, and in which case, then realistically, Sue, how long do you think this could go?
Well, yeah, I agree 100% with Michael. And also remember, the evidence collection and the search are some things that there was some inconsistencies in. You know, the defense is making a charge that evidence was planted, that there's no way that all that evidence could have been there. It wasn't found. And then just some of the measurements have been off, the number of pieces of a tail light that were in the evidence bag, when the photos were taken. And remember, the experts that testified for the defense, the reconstructionists, they also had some differing opinions about what happened there. So I imagine that this might be a focal point where they're seeing inconsistencies. And again, sometimes it just might be a small mistake. I'm not trying to make a big thing out of it, but they did call for it to look this report. Now, it doesn't mean a report doesn't exist.
That's a good point.
The report wasn't entered into evidence. Now, are they going to wonder, well, does a report exist? And if it does exist, why wasn't it put into evidence? And remember, the witness that testified about the search was very credible and very good, one of the best witnesses that the prosecution had. So they may be looking to this to be a place for them to pull things together. But there's more evidence and more things that they could be looking at. So to your question of how long could this take, it could take a while if they're being this thorough about, which I expect they are, about all these other pieces. Or maybe it's just something they're disagreeing about. Who knows?
All right. Sue, back at your post tomorrow, please, outside the courthouse. We'll be talking to you then. Thank you, Sue. The impacts of this trial are expected to stretch far and wide, beyond the walls of the courthouse, and we're starting to see ripple effects in the town of Canton.
The town select board voting on the future of the Canton police chief last night. We'll have more on their decision when we come back.
Throughout this trial, we've worked hard to bring you every angle of the case, including its potential impact on other high-profile cases and on the town of Canton.
Last night, a number of residents spoke at the town select board meeting, many of them calling for a shakeup at the police department. For months, residents have urged board members not to renew the contract of Canton Police Chief Helena Rafferty, even though Rafferty was not chief at the time of O'Keefe's death. The board ended up voting 3-1 in favor of renewing Rafferty's contract, but just for 1 year instead of the standard 3.
We want to get through the trial. We want to get the police audit and give her a chance to respond to what the audit finds and take appropriate steps to correct.
We need a police chief who's concerned about the safety of all Canton residents, not just well-connected townies.
Our team reached out to Chief Rafferty for a comment, but we have not heard back yet. We should note Select Board member Chris Albert abstained from last night's vote. You'll remember Albert testified in the retrial and is the brother of Brian Albert.
Thank you for joining us for Canton Confidential tonight. The first full day of deliberations is in the books. Of course, they did about 3 hours yesterday, and there's more to come.
Yep, the jury will return tomorrow morning to continue working towards a verdict starting at 9 a.m. When they do reach a decision, you can be sure we will be one of the first to let you know. Just download the NBC 10 Boston app and enable breaking news notifications. We'll see you back here tomorrow at 7. Have a good night.